Good morning. Today we are going to analyze one problem question on joint tenancy and beneficial interest. The video content has been made available for informational and educational purpose only. Kindly go through the disclaimer completely. Let's start with the problem question. In January 2017, Andy, Bob, and Bob's mother, Cynthia, bought a house together for them all to live in. They contributed unequal amounts to the purchase price of the property, and the property was conveyed to Andy and Bob as legal joint tenant for all the three of them as beneficial joint tenants. In 2018, Cynthia told Andy about her hairdresser gossip that Bob was having an affair with Damian. When they confronted Bob, he confessed and told them that he wanted to sell his interest in the house so that he and Damian could buy a new home together. Three of them discussed the possibility of Cynthia's buying the Bob's interest in the house. After several days of discussion, Bob's and Cynthia settled on a price. The next day, Cynthia, enraged by Bob's behavior, and changed her mind. A week later, Andy sent Bob and Cynthia a postcard telling them that as she was making plans to move abroad in the next year, they should respect her wish to claim her interest in their house. There was no room for Andy to add her signature. She posted the card on her way to work in the morning. However, and the unbeknown to Andy, industrial action by postal workers meant the postcard was not only delivered to the house 3 days later. In the meantime, she got a message at the work to say Bob had been rushed into the hospital. When Andy got home that evening, she immediately left a note for Bob and Cynthia on the hall table telling them to ignore her postcard because she had changed her mind. Bob died the following day. In his will, Bob left all his property to Damian. In 2021, Cynthia was diagnosed with a rare skin condition. She mortgaged her interest in the house to elderly bank to pay for a private therapy room to be built in the garden. She has recently been unable to keep up her monthly repayments to the bank. Auntie and Cynthia now want to stay in the house, but elderly bank want it to be sold. Advise elderly bank about who is entitled to the proceed of the sale and in what shares and whether the property is likely to be sold. How, if at all, would your advice differ if Cynthia had been declared bankrupt? So we have to advise in two different ways. Legal and beneficial co-ownership. In 2017, Andy, Bob, and Cynthia established a legal joint tenancy while intending to share the beneficial interest as a joint tenants. As per the case law, the joint tenancy can be severe under certain conditions, notably those outlined in Williams versus Hensman. A unilateral declaration of intent to sell by one joint tenant, Bob, does not constitute severance on its own, as it lacks the mutual agreement among all the joint tenants. Notice of severance. Andy's postcard can be considered a notice in writing under Section 36 of the Law of the Property Act 1925. However, the effectiveness of this notice hinges on whether it meets the requirement for severance and when it is deemed served. According to Section 196 of 3, the notice is effective upon reaching the house, which in this case was 3 days post mailing. During that interim, Andy attempted to revoke the notice by leaving a note. A legal question arises. Does her revocation occur before the notice is effectively served? Following the Kinch versus Bullard, it appears she can revoke before the service, meaning the original joint tenancy could remain intact. Severance of joint tenancy. The case of Williams versus Hensman discusses how a joint tenant can sever the joint tenancy through acts such as selling their interest or mutual agreement. Cynthia's action do not indicate a clear severance since no formal agreement to purchase Bob's interest was concluded. Intention to serve severe in Burgess versus Ransley, it was established that the mutual intent to sever a joint tenancy must be clear. Although Bob's intention to sell was expressed, there was no final agreement before his death. A postcard notification, the Andy's postcard might be seen as an attempt to claim her interest, but it lacked a signature and was not delivered immediately due to postal delays. In Huxley versus May, the court considered the effectiveness of communication in severing the joint tenancy where the intention must be clearly communicated. Bob's death and inheritance. Bob's death raises the issue of whether he retained his interest in the house at the time of the death. If the joint tenancy was not severed, his interest would pass to the serving joint tenants, that is, Andy and Cynthia, under the principle of survivorship. If severance occurred prior to his death, Bob's interest would pass to Damien as per his will, complicating the distribution of proceeds from the potential sale. So the elderly bank claims and sale of the properties. Cynthia's mortgage with the elderly bank introduces the question of property sale. Under the Section 15 of Trust of Land and Appointment of Trustees Act 1996, the court must consider various factors, including the purpose of the trust and the interest of the secured creditors. Given that elderly bank has a claim against the property, they may have a strong argument for the sale, especially if Cynthia cannot meet the mortgage payments. TLATA 1996, the section 14 and 15 provide guidance on the power of the trustees regarding the sale of the jointly owned property, emphasizing that any owner can apply to the court for a sale. Given the Cynthia's financial difficulties, she may seek a court order to sell the property, but this must consider Andy's claim. LPA 1925, Section 36 allows for the sale of the property by joint tenants with the consent of all the properties for all the parties. Since Bob has passed away, his interest will be governed by his will, which will leave his property to Damien. If the property is sold, the proceeds distribution. Assuming the property is sold, the proceeds would first cover Cynthia's mortgage debit to elderly bank. The remaining proceeds would be divided between Andy and Cynthia, considering their beneficial interest. The division could be equal unless evidence suggests otherwise regarding their contributions. Joint tenancy and beneficial interest. The property was conveyed to Andy and Bob as legal joint tenants, meaning they hold the property together with rights of survivorship. This implies that upon Bob's death, his interest in the property automatically passes to Andy and Cynthia unless there are specific agreements or circumstances altering these. Communication of intent. Andy's intention to claim her interest was communicated through a postcard. However, due to the postal delays, this communication may not be considered effective until it was received. The case of Williams versus Hinsman emphasized that a joint tenant can sever the joint tenancy by giving a notice to other joint tenants. However, the validity of Andy's notice is questionable due to the delay. Upon Bob's death, his interest in the property would typically pass to the surviving joint tenants, Andy and Cynthia. However, since Bob expressed a desire to sell his interest, we need to examine if this intention was effectively communicated and acted upon before his death. Cynthia mortgaged her interest to elderly banks. Under Section 36 LP 1925, a mortgagee elderly bank has a right to enforce the mortgage, which includes the right to sell the property if the repayments are not made. The proceeds from the sale would first be used to satisfy the mortgage debt. Advice to elderly bank. If the property is sold, the proceeds will generally be divided according to the beneficial interest of the parties. Since Bob's interest likely passed to Andy and Cynthia, they might share the proceeds equally unless there are contributions that suggest otherwise. We have to refer to the case Gold versus Kemp and Goodman versus Gallant. Since Bob left his interest to Damian upon sale, the Damian will be entitled to Bob's share. The remaining proceeds will be divided according to the beneficial interest of Andy and Cynthia, contingent on how the court views their respective claims and contributions. Given Cynthia's financial situation and inability to maintain the mortgage payments, the property is likely to be sold to satisfy the debit to the elderly bank. Cynthia may need to apply under TLATA for the sale, especially since she has a mortgage that is in default. If Cynthia were bankrupt, should Cynthia be declared bankrupt, the situation changes significantly. The implication of the Insolvency Act 1988-86 would come into play. The trustees in bankruptcy would have the powers to deal with the property, and the court would assess whether exceptional circumstances exist to allow Cynthia to retain her interest in the house. The previous case law, such as the First National Bank case, underscore the limited options for a bankrupt individual to maintain possession of the property. In the event of Cynthia's bankruptcy, Section 335 of A of Insolvency Act 1986 would apply. A trustee in the bankruptcy would have the right to claim Cynthia's interest in the property to satisfy her creditors. This would complicate Andy's position as her interest could be subject to claims from Cynthia's creditors. Under Section 335A of Insolvency Act, her interest in the property would be a part of her bankruptcy estate, potentially making it subject to sale to satisfy creditors. Elderly bank could push for a sale under these circumstances, as the trustees in bankruptcy would seek to realize the asset. Let's conclude. In advising the elderly bank, the focus should be on the potential for the sale due to Cynthia's inability to meet the mortgage obligations, the status of the joint tenancy post Bob's death, and the implication of any severance. If the joint tenancy remains, the bank may face challenges in enforcing a sale against the wishes of the surviving joint tenants. If Cynthia is bankrupt, however, the bank's position strengthens significantly, allowing for the possibility of the sale to satisfy the mortgage debt. So, the advice to the elderly bank should initiate the proceedings to the sale the property to recover the mortgage debt. The division of the proceeds will depend on the surviving joint tenants Andy and Cynthia, a beneficial interest after satisfying the mortgage. And what is the impact of bankruptcy? If Cynthia is declared bankrupt, her interest would be treated as an asset of the bankruptcy estate, potentially affecting the distribution of proceeds from the sale and complicating Andy's claim to the property. Thank you.